Welcome to Sidebar, a podcast by Courthouse News. I'm your host, Kelsey Reichman, and I'm joined by Kirk McDaniel. Hey, Kirk.
Hey, Kelsey.
It's June, and you know what that means.
Yeah, it's Pride Month.
Yes, but as a Supreme Court reporter, June is also opinion season, and the court has and is expected to rule on some big cases impacting the LGBTQ community.
Coincidentally, we're also days away from the 10-year anniversary of Obergefell v. Hodges, the landmark case that legalized same-sex marriage nationwide. A decade later, the Supreme Court has stayed busy on this issue.
Supreme Court cases are built brick by brick over time. So to understand our current moment, we need to look back at Obergefell's origins.
Homosexuality is an enigma. Even in this era of bold sexual mores, it remains a subject that people find disturbing, embarrassing, and the reluctance to discuss it. Yet there is a growing concern about homosexuals in society, about their increasing visibility.
The voice you heard there was legendary broadcast reporter Mike Wallace from a 1967 CBS broadcast titled The Homosexuals.
It's jarring to hear a major news network denigrating homosexuality in 2025, but almost 60 years ago, that rhetoric was commonplace.
It wasn't just rhetoric. States explicitly banned marriages between same-sex couples and even had laws criminalizing sexual activity of gays and lesbians. Yet ironically, it was laws like these that laid the groundwork for us to get to Obergefell. The history of LGBTQ people in America is as old as the country itself. But for this story, we will start around the middle of the 20th century, when visibility for gays and lesbians is on the rise.
When same-sex marriage began to be a political issue in the 1970s and the 1980s on a much broader scale, that's when states redefined marriage and began specifying that it involved a man and a woman. It was restricted to a man and a woman. My name is Mark Stein. I'm the Jamie and Phyllis Pasker Professor of Constitutional Law and U.S. History at San Francisco State. I direct the Out History website, and the book that I wrote most relevant for our conversation today is called Sexual Injustice, Supreme Court Decisions from Griswold to Roe.
Stein told me that the fight to get where we are today took a campaign to change hearts and minds, as well as the law. He broke them down to three main arguments against LGBTQ rights: criminalizing behavior, religious opposition, and advances in medicine.
Okay, so how about we start with criminalizing behavior around same-sex sex?
Sodomy law basically criminalized oral and anal sex. And that could be heterosexual or homosexual, right? And it was most commonly enforced in situations of sexual violence or same-sex sex or public sex or commercial sex. But theoretically, the way the laws were written, it applied to essentially non-reproductive sex.
Most U.S. states and territories had sodomy laws on the books. Some were even specifically targeted to apply to same-sex couples. In 1967, Illinois became the first in a line of states to begin repealing these statutes.
So the campaigns for decriminalizing sodomy were generally fought on libertarian grounds. Get the state out of our bedrooms was a Canadian expression, but also used in the U.S.
It makes sense that a political philosophy centered on individual liberties and freedoms would lead the charge to repeal sodomy laws.
Well, not all the states were convinced. In fact, at first, the Supreme Court wasn't all that in favor of doing away with them. In 1986, the Supreme Court upheld a Georgia law after a gay man was arrested under the state's sodomy prohibitions in a case known as Bowers v. Hardwick. Bowers was on the books for 12 years before it was successfully challenged by John Lawrence, a gay man living in Texas. The Lone Star State's sodomy laws banned oral and anal sex between same-sex partners. Unlike Bowers, Lawrence prevailed at the Supreme Court. In 2003, the court struck down Texas's sodomy law in Lawrence v. Texas, holding that criminalizing certain intimate behavior violated the Due Process Clause under the 14th Amendment.
Cracks are forming in statutes criminalizing same-sex behavior. What about religious opposition? Where do the cracks start to form there?
More and more liberal religious denominations were challenging the notion of sinfulness.
This was something that happened exponentially over time as LGBTQ visibility increased. In 2007, less than half of U.S. Christians thought that same-sex couples should be allowed to marry. That has grown to more than half of Christian adults in 2023 and 2024, the Pew Research Center found.
Okay, and what about advances in medicine? What did Stein say about that?
The medical community considered homosexuality a mental illness before the 1970s, when the American Psychiatric Association declassified it as a psychological disorder. Years later, in the 1980s, the HIV and AIDS epidemic added a whole other layer of complexity to nearly all the arguments against equal protections for the LGBTQ community.
I do think HIV/AIDS played a really important role in this process. And it's a complicated role because on the one hand, HIV/AIDS created opportunities for the expression of intense and ugly anti-LGBTQ animus. And sometimes that took legislative and legal form. But it is also true that HIV/AIDS raised the visibility of the LGBT community in the public sphere. It certainly contributed to mass mobilization. It created narratives that people could relate to: losing an apartment lease after a spouse died, paying dramatically greater estate taxes because of the non-recognition of same-sex marriages, and even denial of visiting rights for spouses in healthcare institutions and hospitals specifically.
Losing their loved one to AIDS, gays were confronted with the fact that they lacked the same legal rights that straight couples enjoyed. Relatives of the deceased came in to collect the deceased's belongings, and their partners had no way of asserting what property belongs to them.
Those, I think, were important for, say, the middle slice of the American public to move in important ways towards supporting basic LGBT rights. And yes, I think that then contributed to some of the early moves on the part of states.
In the wake of the epidemic, we start to see states permitting same-sex marriage or civil unions to ensure these vital spousal rights were afforded to same-sex couples. It wasn't some great awakening as much as it was a necessity.
In the early 90s, that included Vermont, Hawaii, and then ultimately Massachusetts as the first states to, mostly through court action. Later, we would get some legislatures, state legislatures as well. But initially, courts, not accidentally in liberal states, begin to shift.
Advocates for same-sex marriage began to gain a foothold, developing the arguments boosting marriage equality. But just as they are gaining ground in some states, other setbacks hit.
For a while, we really did have the states as the laboratory of democracy where things were evolving at the state level. But ultimately, because in the Clinton era, and we have to remember that it was the Clinton era, Congress passed the Defense of Marriage Act, there was this large problem looming because of the thousands of benefits that federally that people get on the basis of marriage.
The Defense of Marriage Act of 1996 set the ceiling for the movement, banning the federal government from recognizing same-sex marriages.
But remember, in 2003 in Lawrence v. Texas, the Supreme Court outlawed sodomy laws.
The next advancement wouldn't come until 10 years later in United States v. Windsor, a New York woman who was married to her wife, Thea Spire. The couple was legally married in Canada but lived in New York. The Empire State was a fellow safe haven for gay couples. But when Spire passed away, Windsor was denied a federal estate tax exemption for surviving spouses because of the Defense of Marriage Act.
Windsor challenged the denial all the way up to the Supreme Court, and in 2013, the justices found that the statute violated the Fifth Amendment right to equal protection under law. In United States v. Windsor, the Supreme Court ruled that the states, not the federal government, have the authority to define what marriage is.
Windsor pushed marriage equality closer than ever before, leading right up to Obergefell. A collection of same-sex couples from Kentucky, Michigan, Ohio, and Tennessee formed the basis for the landmark Supreme Court case, Obergefell v. Hodges. Of the couples named in the lawsuits, many of them were wedded in places where same-sex marriage was legal, but suing the states they resided in, seeking to have their unions recognized. The lead plaintiff in the case, Jim Obergefell, sued his home state of Ohio over its refusal to recognize his marriage to his husband, John Arthur. In 2013, just 2 years after learning that John had ALS, the two got married in Maryland, where same-sex marriage was legal, and returned home to Ohio. When John passed away, the state denied Jim's request to be named as his husband's surviving spouse, citing Ohio's law banning same-sex marriage.
When a case comes to the Supreme Court, they're always answering a specific legal question. Here, it was whether state bans on same-sex marriage violated the 14th Amendment of the Constitution. As a refresher, the 14th Amendment guarantees equal protection under the law.
To peel back the layers of that argument, I spoke with someone who has worked as an LGBTQ rights lawyer and now teaches in this area of law.
My name is Lee Carpenter, and I'm a law professor at Rutgers University. The idea is that the 14th Amendment has kind of two important components to it, and two legal concepts that really bear on the question of same-sex marriage. One is the Equal Protection Clause. And I think what's important for listeners to understand is that the Equal Protection Clause essentially tries to ensure that categories of people are treated equally where there is no meaningful difference between them.
It was this exact argument that led to the Supreme Court's ruling in Brown v. Board of Education, ending racial segregation in the United States. Separate is never equal sums it up nicely.
The other idea that I think is important and a little harder for people to understand is the Due Process Clause, because the language of the Due Process Clause suggests that it's just about the idea that the law has to allow you to undergo a fair process, like you need to get a fair shake under the law.
You might have heard a lot of discussions in the news about due process in the immigration context. Not sending people to foreign mega prisons without a court hearing. That kind of due process refers to legal proceedings. There's a slightly different context here.
That's not the kind of due process that we're talking about with respect to marriage equality. There's another idea that has been sort of read into the Constitution, and that's the idea of substantive due process. The idea that you should not be prohibited from engaging in activities that in such a way that your liberty is impeded upon. The idea that you are generally free to do things the way that you want to do them, and the government can't impinge upon that, right? So you can imagine that the question of same-sex marriage bears on both of those things.
That's the broad strokes of it. In addition to Professor Carpenter, I also spoke with someone who has worked on the Obergefell case, as well as many others dealing with marriage equality.
My name's Jenny Pizer. I'm the Chief Legal Officer for Lambda Legal. And Lambda Legal is a nationwide nonprofit legal advocate for the LGBTQ plus movement. We do civil rights litigation and policy advocacy and public education to advance the legal rights of LGBTQ plus people and everyone living with HIV. The litigation, including in the Obergefell case, was about systematically challenging the different arguments that the governments were putting forward to test whether they were legitimate, whether they were important, and whether they were adequately closely related to what the government was actually doing. The family law area, has received special protection, that we are to have a kind of freedom and privacy to create and run our family lives without the government sitting there at the kitchen table telling us, whether our child needs a timeout or not, or telling us what food we're allowed to eat, or who should make the financial decisions in the family, or any other innumerable decisions that make up family life, that is really not the government's business. Unless somebody's being harmed in that environment, it really is for us as free Americans with liberty rights to have the government leave us alone, provide us certain kinds of protections in the legal system, but not be taking over our private business.
Okay, I follow you. For the close court watchers, you'll know that substantive due process is a boogeyman for legal conservatives. Justice Clarence Thomas has specifically noted his distaste for the concept. These anti-substantive due process arguments are identical to the opposition in Obergefell.
I'll let you hear it directly from someone who presented arguments in the case.
This is John Bursch. I'm the Vice President of Appellate Advocacy at Alliance Defending Freedom. That means I supervise all the U.S. Supreme Court and federal and state court appeal litigation. I'll just note for the record that when I argued Obergefell, I was not yet at ADF. I was representing the state of Michigan in that case in my role as a private practice lawyer. The main argument we made was that the Constitution was silent about the definition of marriage, and therefore the issue was left to the states to decide, acting through the democratic process, whether that be the legislature or people acting through ballot initiatives and things like that. And I don't think anyone has really answered that question between the time that we argued Obergefell in April of 2015 and today.
That argument seems to conflict with Loving v. Virginia, which found state bans on interracial marriage unconstitutional under the 14th Amendment. How does Bursch differentiate same-sex marriage?
Yeah, I actually asked Bursch about that argument. He pointed to what he viewed as the definition of what a marriage was in the eyes of government.
The response then is the same one that it is today, which is that is a false comparison, because the government doesn't have any business in regulating personal relationship. The government has no interest in relationships, except when you're talking about a man and a woman who are coming together in a conjugal relationship where kids are the natural byproduct. Then the government has a strong, compelling interest in making sure that those children are connected like glue to their biological mother and father for as long and as much as possible. And so when the government instead tries to regulate relationships based on feelings, it changes the entire nature of the institution. So to get back to your question, someone's race has nothing to do with their procreative capacity, their ability to have a child. And so it doesn't have anything to do with marriage. But the complementariness of a man and a woman and their ability to conceive a child has everything to do with the government's interest in regulating that relationship and trying to keep that family unit together.
That ended up being a losing argument.
History is written. The Supreme Court guarantees marriage for all. There's a rush for licenses in more than a dozen states where same-sex marriage had been illegal.
Now to that historic Supreme Court decision legalizing same-sex marriage across the land, and it's profound. The 5-4 vote, in many ways reflecting the huge societal shift of the last 20 years.
It's the most important gay rights ruling ever, and it's the culmination of decades of legal battles. It comes from a Supreme Court that just 30 years ago said gay people could be punished as criminals.
I'd like to thank John for loving me, for making me a better man, and for giving me something worth fighting for. I love you. This is for you, John.
That last voice you heard is the lead plaintiff, Jim Obergefell, speaking about his husband, John Arthur. 2 months after the case was submitted, the justices handed down their ruling. On June 26, 2015, the right to same-sex marriage became legal nationwide. Here's Justice Anthony Kennedy reading from the court's majority opinion.
The court's cases touching upon the right to marry, as well as its cases addressing the legal treatment of gays and lesbians, have long emphasized the relation between liberty and equality. The court now holds that same-sex couples may exercise the fundamental right to marry in all states. No longer may this liberty be denied to them. The challenge laws excluding same-sex couples from marriage cannot stand under the Constitution. These cases also present the question whether the Constitution requires states to recognize same-sex marriage that were licensed in other states. In light of the court's holding that same-sex couples may exercise the right to marry, it follows that the court must hold, and now does hold, that the challenge bans on recognition are invalid.
Marriage equality advocates like Jennifer Pizer at Lambda Legal were pleased with the decision, to say the least. She told me it was significant how Kennedy acknowledged something about same-sex couples that they had long fought to have others in the public arena recognize.
Stands out in particular about the majority opinion as a starting place is a recognition that same-sex couples love each other, are committed to each other, and want to marry for the same types of reasons that different-sex couples do. He has language about same-sex couples want to honor the institution and respect the institution by participating in it, not to be critical or damage the institution, really to the contrary.
What about John Birch? What was his reaction to the case?
Well, going back to his arguments, a central issue was that this was something that should be decided by the states, and the U.S. Constitution was basically silent on the question. Here's what he told me about the decision.
I do think it's dangerous when the U.S. Supreme Court creates rights that don't exist anywhere in the Constitution or the history and tradition of the Constitution, because whether you like it or not is going to depend on how they're deciding each issue. And it's really hurting democracy when they take away those conversations from the public. Obergefell was a particularly egregious instance of that because only 40 years earlier, a unanimous court had recognized that the federal Constitution had nothing to say about the definition of marriage, that states should do that.
The court's four most ideological conservatives saw the decision as a grave overstepping of the court's authority. Chief Justice John Roberts, reading from his dissent, said that the court was effectively saying what the law should be.
But today, 5 lawyers have ordered every state to change its definition of marriage to one that matches a new one that they favor, because those lawyers have, in their words, new insight and a better informed understanding of liberty. Just who do we think we are? I have no choice but to dissent. These cases are not about whether we think same-sex marriage is a good idea. The petitioners make strong arguments rooted in social policy and considerations of fairness. They have moving personal stories. Stories like theirs have played a major role in persuading voters and legislators in 11 states and the District of Columbia to revise their laws and adopt same-sex marriage. But this is a court, not a legislature.
It's worth mentioning that the makeup of the Supreme Court has changed drastically since 2015. 10 years later, in 2025, Roberts' arguments are more widely shared among the conservative supermajority. But we'll get to that after a quick break. Listeners, I don't have to tell you that there's a lot going on under our new administration. We know you love our daily, hourly, and let's be honest, minute-by-minute coverage on socials and online at courthousenews.com. But your favorite sidebar reporters are taking a much-needed summer break. Don't worry, that just means you'll have more time to catch up on all our latest episodes, which seem to be more relevant every day. Check out Josh Russell's coverage of Trump's attacks against Big Law, or my episode getting into the nitty-gritty of the unitary executive theory. Find those episodes and more from Sidebar, wherever you get your podcasts.
Something that stood out to me when I was talking to Mark Stein, the gay rights historian from San Francisco State, and Lee Carpenter, the Rutgers law professor, was how they viewed the ruling. In a nuanced way, both saw the decision as somewhat disappointing, not for its outcome, but for the way the majority went about answering the important questions.
I was a little disappointed in the majority opinion. This is something people are like, how can you be disappointed by Obergefell? I think that for some of us, the Obergefell opinion is very reliant on the sort of important symbolic value of marriage. It's less kind of nuts and bolts. It doesn't go into the equal protection argument as much as some of us wished that it did. And it spends a great deal of time talking about sort of this symbolic power of marriage. Because of that, the Obergefell decision has sort of limited utility outside of the question of marriage because it spends so much time talking about that and a lot less time talking about you can't discriminate against gay people.
And here's Stein.
I'll read the key passage in Kennedy's conclusion that elicited the complaints from LGBTQ radicals or people who favor a greater diversity of relationship forms. Kennedy wrote, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family.
In forming a marital union, two people become something greater than they once were and would misunderstand petitioners to say that they disrespect or diminish the idea of marriage in these cases. They're pleased that they do respect it. They respect it so deeply they seek to find its fulfillment for themselves. They ask for equal dignity in the eyes of the law, and the Constitution grants them that right."
Now, that's a very beautiful paragraph. It really is, and it brings a tear to many people's eyes. But it is a very romanticized and idealized and a very particular idea of what marriage is. It is not the vision of marriage that sees it as a transactional relationship or a transactional contract. It certainly does not take into consideration the explosion in divorce rates in the second half of the 20th century in the United States and elsewhere. Kennedy's decision in Obergefell fits the pattern in that it doesn't address really openly or explicitly private discrimination. The door was wide open after Obergefell for private discrimination to be sanctioned.
In the years since, the Supreme Court has built on Obergefell, boosting LGBTQ rights. The most notable of these cases coming in 2020 with Bostock v. Clayton County. Gerald Bostock sued his employer, Clayton County, claiming he was fired because he was gay. The 1964 Civil Rights Act prohibits discrimination based on sex. But what about sexual orientation? In a somewhat unexpected 6-3 ruling, the Supreme Court said yes, recognizing that LGBTQ Americans must also enjoy those landmark discrimination protections. However, in the years since, there's been questions about whether Bostock marked a trend or an aberration. Which brings us back to Roberts' dissent in Obergefell. His opposition to recognizing the right to same-sex marriage feels a lot more familiar with the shift the Supreme Court has taken in the last 5 years.
I assume you're referencing the two big cases related to this topic, the Masterpiece Cake Shop v. Colorado Civil Rights Commission and 303 Creative v. Elenis. In the Masterpiece case, a same-sex couple sought to have their wedding cake made by Jack Phillips. Citing his Christian faith, Phillips refused, and the couple brought discrimination claims against him.
The Supreme Court sided with the baker, finding that his rights were violated, but the justices didn't rule on the broader question of whether forcing an artist to create a work that violates their deeply held religious beliefs is a violation of freedom of speech.
Which is why we have the case of Lori Smith, a graphic designer who owns her own business called 303 Creative. She sued the commissioner for the Colorado Civil Rights Division, challenging a law that prohibits public businesses from discriminating against people based on various factors, most importantly to this case, sexual orientation.
This time, the Supreme Court, in a 6-3 ruling, found that the First Amendment prohibited Colorado from forcing a website designer to create expressive designs that convey messages with which the designer disagrees.
The Alliance Defending Freedom helped advance these cases, and they came up during my conversation with John Bursch, specifically what these cases meant in a post-Obergefell country.
Creative professionals after 303 Creative, which was an Alliance Defending Freedom case, no longer have to worry about state officials compelling them to create messages that violate their beliefs. So things like that help, certainly. But there are still thousands of individuals and churches and religious organizations who are suffering discrimination because they won't get on board with LGBTQ orthodoxy. So Obergefell really did set up a conflict that the Supreme Court has not yet been able to resolve. And it's going to take many, many, many more cases before that's going to be over.
On the questions of religious liberty and public accommodation, LGBTQ advocates would argue that these carve-outs essentially sanction discrimination. Here's Carpenter again to explain.
Given this makeup of the court, we're going to see increased religious carve-outs, right? For people saying, I don't want to have to serve LGBTQ people. I don't want to have to do anything to facilitate an LGBTQ wedding. The question is how far that goes, right? I think that many people are sympathetic to the idea that, if you have a small business and you're making, wedding websites, that you shouldn't be forced to make one for a same-sex wedding if that's very upsetting to you and offends your religious beliefs. I think a lot of Americans who, are of completely goodwill to LGBTQ people, and a lot of LGBTQ people see that as being reasonable. The real question is how far does that go, right? Does that extend to you're the only bakery in town, right? Does that extend to you can't get this service somewhere else? Does that extend to you're the last gas station before you hit Death Valley, right? That's sort of where where this might be going, and it's like how far do the goalposts get moved? And I think that's an issue of real concern for a lot of people.
Mark Stein at San Francisco State gave me some insight into how the court could expand protections for the community under Obergefell and Bostock, but seemingly rule against it in Masterpiece and 303 Creative.
So we have those positive decisions, and what all of those have in common, I would argue, is that they involve government action. And we know that the court always or generally holds a government to higher standards, in a sense, than it does private individuals or private businesses.
So those have been the recent cases, but as I understand it, Kelsey, you have been covering some upcoming cases that will be adding to this legal history.
That's right. Let's start with Mahmoud v. Taylor, which will decide whether Maryland parents can use a First Amendment loophole to keep their kids from reading books with LGBTQ characters. The justices will decide if the Constitution requires schools to work with religious parents to shield their children from information that conflicts with their beliefs.
Bursch told me that the Mahmoud case specifically is poised to follow in the steps of 303 Creative.
Well, thinking about that Mahmoud case, it really has to do with the fundamental ability of parents to be able to raise their children the way that they want, even when they're going to the public schools. If you had a student, say in fourth grade, who didn't want to sing in the choir class because they were singing a song and the word God was in it, the parent had the right to opt out their student from that choir class. But if a 4-year-old was being read a book about gender identity, the parents did not have the ability to opt their child out of that class. And so I think that strain of religious persecution is something that has increased exponentially since Obergefell. We talked about Jack Phillips and Laurie Smith and many other examples of that. And I think until we can get that problem fixed, it'll be difficult to even have the underlying conversation about the principles. Like, what is good for kids? What is the meaning of the human body? What does it mean to be created male or female? Is that a gift that you accept and you embrace? Or is it something that you reject because we have the ability to say for ourselves, what we want to be? So I think Mahmoud is going to be an important precedent.
What worries LGBTQ rights advocates about these cases is the weaponization of religious freedom to deny equality to LGBTQ people. In the wake of 303 Creative, a Michigan hair salon owner announced on Facebook that transgender people were not welcome at her business. Down in Texas, Waco judge Diane Hensley argued that the ruling strengthened her case for refusing to perform LGBTQ weddings.
While not directly related to same-sex marriage, supporters of LGBTQ rights point to this current moment, while the spotlight is on transgender people, as the chipping away of protections for the community as a whole. Here's Jennifer Pizer at Lambda Legal again.
Having the president with his bully pulpit and through his campaign saying all kinds of outrageous false things about transgender people has had a negative effect. It affects what people think about other people that they don't know very well. And it is true that we see, at least public opinion research shows a drop in support for marriage equality for same-sex couples among people who identify as Republican.
A Gallup poll showed Republican support for same-sex marriage dropped from 55% in 2022 to 46% in 2024. While the poll doesn't explain the drop in support, Professor Carpenter argued that the current anti-trans rhetoric has played a role.
What the attacks on transgender people should be seen by LGBT people as a step toward coming after them, right? Because they're not. This particular enterprise is not going to stop at dehumanizing transgender people. They're just not, because that's not the project. The project is not, if we could get rid of transgender people, we would have the utopia that we seek, right? The project is relegate everybody who is not straight and white to a lesser status. And no matter how successful you may be as an LGBT person, and no matter how well assimilated you may think you are, you will never be the person who this particular group of people see as the deserving top of a hierarchy.
The Supreme Court has put itself in the middle of the fight over transgender rights. Recently, the justices issued their most highly anticipated ruling of the term, United States v. Scrimetti. This was a challenge to Tennessee's ban on gender-affirming hormone therapy for minors. Transgender minors, their families, and a doctor argued that Tennessee's ban discriminated based on sex and transgender status. They relied on the Equal Protection Clause of the Constitution and the court's 2020 ruling in Bostock v. Clayton County. In the 6-3 ruling in Scarametti, the conservative supermajority upheld Tennessee's ban, but the majority opinion avoided ruling on most of those key arguments. Since the Supreme Court didn't rule on Bostock or the other important trans rights issues in this case, we are almost certain to see trans rights come back up at the Supreme Court. A lot of this rhetoric has people asking another question. Could Obergefell be overturned?
I posed that question to the experts I talked to and was told that appears unlikely at this moment.
Well, I don't see anybody attempting to overturn Obergefell right now.
There's no current case that I'm aware of that would present the question to the Supreme Court. However, there are cases percolating in courts all over the country all the time, and a case theoretically could get to the court with that issue injected.
I don't see the conservative movement making same-sex marriage a priority. And even if we take as a proxy what's going on in the president's inner circles, there are gay men in marital relationships in his cabinet, right? And that sends a signal, right? And it's actually kind of striking. That would not have been the case for either of the Bushes, and certainly not for going back further, Nixon, Ford, or Reagan. So I think they're really going after trans people, and they're really going after colleges and universities and immigration. And when those intersect with LGBTQ issues, sure, that's going to be part of the campaign, but I hope I'm not proven wrong, but I don't see the conservative movement in general, the Republican Party and the Trump administration most specifically deciding to make the undoing of same-sex marriage a priority.
Obergefell is safe for now, I think, because it is not number one on the agenda. But I think it is very important for everyone who is concerned about whether Obergefell will remain safe to understand that the fates of a lot of different minority groups in this climate, and always, but particularly now, are linked, right? The ability for women to access reproductive care, the ability for transgender people to serve openly in the military and obtain the care that they need, right? The ability for people to have non-discrimination programs in their places of employment. All of these things are linked together. So I think my last sort of suggestion for people is, if you are worried about Obergefell, worry about those things first.
On top of this lack of desire to take on the precedent today, we also have federal legislation protecting same-sex marriage.
Yes, and that would be the Respect for Marriage Act.
That's the one. This 2022 law repealed the Defense of Marriage Act and made it so that the federal government and states must recognize same-sex and interracial marriages. What is significant about this law is that it was supported by both Republicans and Democrats, which alone tells you just how far the nation has come on this issue. So, legally speaking, there are protections today that would stand in the way if, say, Obergefell were to be overturned. It's also worth mentioning that while there's no current case that directly threatens Obergefell, there are many people out there who still actively call on the Supreme Court to overturn it. On June 10th, it was reported that the members of the Southern Baptist Convention voted in favor of a resolution calling for such an action. Several Republican-led states have passed similar resolutions that, while not having a legal effect, sends a very strong message that for many in this country, this conversation is not over.
Covering decades-old precedents that might be upended by the Supreme Court has kind of become my specialty. Thank you, Kirk, for an excellent history lesson on Obergefell. It was the perfect send-off to Sidebar's summer hiatus. When we return in August, Amanda Pampuro will teach us all how to touch grass. Amanda is taking us all to the great outdoors with a special episode on our national parks. Make sure to subscribe to Sidebar on all your favorite streaming platforms so you don't miss out. If you liked this episode and wanted to share your thoughts, leave us a review on Apple Podcasts. For more stories like this, check out courthousenews.com or our social media pages for more. See you next time.